Welcome. Welcome, welcome, welcome. Welcome to another segment of the Seek Elevation Experience with yours truly, Attorney Alakisha. Yes, I am an attorney, but I may not be your attorney. So I'm not giving you legal advice with this information. What I am doing is giving you education that may encompass some legal information or legal gems. But if you want an attorney, you have to hire one to delve in deeper with information that I am given. But I am elevating you with all of this information as an educator, as a transformational educator. But right here on the Seek Elevation Experience is where real issues, real people, and real conversations take center stage. Because change doesn't happen in silence. From sports and entertainment to business and community, we break down truth and we spark meaningful change and elevate voices that needs to be heard. In this space, though, we don't just talk. No, we empower, we inspire, and we challenge the status quo. So whether you're an athlete, you're an entertainer, a business leader, or just someone striving to have a better life, these conversations are for you. So I want you to go ahead and just tap in. Go ahead, share this with other people. Today is going to be a great day to grow. And that's what this environment is for, environment of growth. This is for seekers who are looking for an environment of growth. When you come here to this segment, this series, this Powercast, Empowercast, whatever you want to call it, when you come here, you're coming here when you are seeking an environment to grow. So go ahead and share this segment today. I am streaming on our regular day at our regular hour, but this is pre-recorded because I have something very important to attend. But there's nothing more important than continuing to help you elevate. So although I'm not here right now, actually on this day, I have invested time to make sure that you are still able to get your meal today. Habits are important, right? When we form great habits, we start to open up the floodgates for us to continue to expand and grow. And I want you to get into a habit that Tuesday, 7 p.m., you are going to show up and show out in the environment for growth. So this right here is for you. And I picked this very specific topic for this day because it's just me. When we get back next Tuesday, I will have some guests on again, and we're going to talk. We're going to, pick up from there. But today it is me and you, because this is very important education today. This is everything that we're talking about, right? This is one of the important things that it hinges upon. The information that we are actually receiving, we have to apply it. And this day, we're going to talk about a way that it is always applied, right? In a legal way. Legal touches every aspect of our life. Even when we don't put it in the forefront, it touches every aspect of our life. When you pick up something and you read it, there's some type of legal component to that, either within the information you're reading itself or the source and how you actually got the information that you're reading. Legal touched it in some way by either protecting it or you're reading some information where there's some type of legal entanglement. So we're going to get into it. What are we talking about today? Alakisha, what are we talking about? What are you saying? Signed, sealed, and screwed. Not anymore. So you already know from that title, we are talking about contracts. We are talking about contracts, and I'm going to give you some information that is going to help you in so many ways, not just as an entrepreneur, not just as an athlete, not just as a creative, but as an employee. Contracts touch all of us. So I'm going to go ahead and get into it. Listen, signing a contract, which we do a lot of times, if you just think about it, like I said, legal touches everything. So even if we're using social media platforms, there's a contractual agreement present with us using that social media platform. When we use our telephones, there is a contractual agreement present with us using our cell phones. I've seen us post, especially here lately, being up in arms about sensitive information, individuals having access to sensitive information, or a lot of times when we are agreeing to use certain platforms, use certain devices, we already contractually agree that sensitive information will be accessible. And it made me think about that because we're up in arms when it's blatantly in our face being told to us that that's being done. But we're not up in arms when we're actually using a platform to express our frustrations that is being done on, when that particular platform also have access. We agree just by moving forward, that is our signature. It's already provisions and terms typed up on the back end that we do not take time to read all the way through. And when we hit yes or move forward or we go, or when we visit certain websites, things that we go ahead and we use or utilize, that is our signature saying we agree to the terms that we don't even know we're agreeing to. Even when we go to our health providers, for me, I read mostly everything. Like, this is my area. Contracts is definitely my area. So a lot of times, most of the times, anytime I'm handed something or participating in something and I know there's some type of contractual agreement, I'm going to read through it. Now, do I do that every single time? No, because I know there's some things that I'm going to do, right? I'm going to do it. And I don't read through every single thing when I know that is the case. But most of the things, and most than the general public, I do that. So whether it is the contract with my phone, the contract understanding social media, making sure I stay up on, the updates and upgrades that they may roll out that automatically enrolls me into something. I make sure I, enroll out, but I do understand what I'm giving up to use something. And if it's something I don't want to give up, then I'm not going to use it. But even when I go to my doctors, I read. And I remember on 2 occasions, one, I went to my general health care provider and I read the information and I went up and I said, I don't agree with this. I don't agree with this. I don't agree with this, which the young lady, the receptionist sitting there, was very shocked, right? Because everybody just signs. We understand the HIPAA. We understand all the basic stuff. We understand that we're signing that we're responsible for pay. But there was other things in there I didn't agree with. Long story short, we end up, I said, this is how I feel comfortable. I want to circle this initial and make notation here. And she went to check and they said, absolutely fine. When I went to go see my OBGYN, same thing. There was, something that I had to get done because at that time I was experiencing a fibroid issue and there were some testing, some things that I had to get done. And when I received the contract to get the thing done, I was reading and I was like, oh no, I have a question about this, question about this, question about that, marked it up, sat with my gynecologist, and we talked about it. And he was like, oh, no, don't worry. This is just in here. This is standard. This is a part of it. This doesn't even apply to what you have going on. I'm like, well, if it doesn't apply to me, then I really do not feel comfortable just signing the document because it doesn't apply to me. And then, we had a conversation back and forth that is pretty much a template thing. And I said, well, I'm not a template person, because at the end of the day, if something does happen, or if we verbally say something doesn't apply and all of a sudden something changes, I don't have a leg to stand on, because it doesn't matter what I said verbally. It matters that what I signed last. So we end up, again, circling, marking off, initialing, and all the things. So it is important that we read, because even sometimes when we're given something by individuals, they don't even know what's in it. They're giving it to you. I know there's a lot of times I go out and we may, be doing an activity where you're supposed to sign a waiver for the activity and all types of things. Sometimes people will say, here, this is this, and they summarize what I'm signing. Here, can you sign this next? It's going to be this, and this. Just go ahead and sign. And this. You know how they summarize right before you initial, like when you pick up your prescription, or if you do anything, they summarize it. While they're summarizing, I'm still reading. And you could tell the, anxiousness and frustration, like, I just told you what it is. Why are you reading? No. You told me what you learned about this, right? You told me your script. You told me your spiel. Because when I have questions about the thing in front of me, you can't answer that, or you didn't even know it was in there, because it's out of the parameter of your script or your spiel. So just because people put it in front of you and they sound so knowledgeable, giving you the information that they have practiced saying over and over again, doesn't mean they're knowledgeable about that document that's in front of you that you're about to sign, with provisions and terms in it that's beyond the summarized script that you're given. So I signed, and in their anxiousness is fine, because I'm going to read it so I could decide, what I want to do, or I can ask the questions I need to ask. And that's how it is. That is how contracts touch us. So we just think about contracts a lot of times on certain levels, right? Doing deals or just certain levels. And even within that, which I will get into it, we don't even drill down far enough or do our due diligence with contracts when we even expect a contract to be a part of that transaction. And signing a contract without understanding is like playing a game without knowing the rules. And that's no fun, right? That's just guessing. That's a crapshoot. I'm going to play this game. I have no idea what the rules are. So I don't know if I'm winning or losing. Someone else can tell me I'm winning and I'm losing, or tell me I'm losing and I can actually be winning. Or they can switch up the rules on me. And I would just think that is what it is. And that is exactly what signing a contract without understanding it is doing. The only difference is it's not a game. When we're signing contracts, and when contracts are put in front of us, they're put in front of us for a reason. It's a very serious matter. And too many careers are destroyed by not knowing what's in a contract and later saying it was a bad contract. I signed a bad contract. And not to be insensitive. I'm not saying this to be insensitive. I say this to my clients, my circle, even myself, which is the reason why I read things that I'm taking very seriously. Is there really such thing as a bad contract after we sign it? Now, you're right. It may be, whoever says it, you're right. It may be a bad contract or not favorable to you. But whatever it is, it was that exact thing before you signed it. It wasn't changed afterwards. Either if it was, then you have a way to get out of it, right? That's illegal. That's illegal. So if something is signed and later argued to be bad, that means it was bad before the signature was laid on that paper. So that's why it's important to do our due diligence, catch what we deem a bad contract or terms or provisions that are not favorable to us before signing it and then going back saying it's bad. And usually that happens, especially in sports and entertainment or with a major business deal. Usually that happens when you have one party who is very, very, very serious about the transaction, making sure they do all their due diligence, hire the right people, usually the one who is presenting or the drafted contract. That's the one party. Then you have the other party who was just extremely excited about what appears to be an opportunity. Just extremely excited. Either excited because they feel the money may change their life. They're excited by affiliation of whoever's on the other side that they're doing this deal with. And in their mind, they just want to do it. So they're not even reading that contract. And if they do read it, they're probably only reading one thing: how much, or what is connected to some type of compensation gain. That's it. And then later, when the deal is signed and the business transaction is happening, and all the excitement comes down, realize, you know what, this is just another person. This was just another opportunity. And all the excitement comes down, then they come to their senses, and then they realize, wow, I should have read that contract. I was blinded by anxiousness. I now have sight, I see, and I was blinded and signed something that now I deem bad. So by the end of our conversation today, I want us to really just talk about, some provisions that we should definitely look at. Of course, I can't go through all of them for the sake of time, but I am going to point out some of the most important ones that individuals do look over, and how businesses and industries, use terms, how they use terms hidden in plain sight to control someone's work or someone's situation, and literally hidden in plain sight because it's right here. It's here for you to see it, but depends on how that whole entire contract is drafted. It can be kind of hidden. Right. And we'll talk about some steps that you must take to just protect your leverage, protect your ownership, protect your ideal of why you are even entering this transaction, protect your interests. So again, it doesn't matter if you are an entrepreneur, if you're an employee, a creator, an athlete, you really need to understand at least the basics of contracts. You have to understand that signing a contract a lot of times come with that negotiation, right? You need to understand what is it to negotiate, and what is it to just maintain control over whatever it is that you need to maintain control over. That could be your intellectual property, or it could be a situation that helps secure your financial future. Whatever it is, this contract is tied to something that you need to maintain control over, even if that means maintaining control over your voice. A lot of people lose their voice in signing a contract. And why does this even matter? Right? Why does this conversation even matter? For those reasons I just said. And I want us to step back. The first advice that I'm going to give you, or I should say, I use advice loosely because I'm not giving you legal advice, but business advice, professional advice, me to you advice. The first thing I would say is any contract you're entering into, whatever side you are on, make sure you step back and put anxiousness aside. And this is why I tell people, it's best to hire someone. And see, a lot of people who enter into contracts and say, I don't need to hire anyone. I could do this. This is an easy contract. I've had plenty of people say before that, it's only a 1-pager or 2-pager. It's real simple. I don't need to hire anyone. I can actually do this. Save money in my pocket. But outside of it being a 1-pager or 2-pager, which I must say, there can be a loaded gun in a 1-page contract. There can be a loaded gun in a 2-page contract. To be honest with you, one of the tactics is to make things appear simple that is actually potent. So if you get something 1 or 2, that can be one of the tactics. Yes, in general, legal documents try to give you 10, 15, 20 pages. To lose you is a whole lot. But sometimes there's conversations that we'll sit and talk, try to make this look as simple as possible, while within that 1-pager or 2-pager is actually loaded. And again, if you hire someone, one, you remove yourself because you may be anxious. You may just be extremely excited about the opportunity. Remove yourself and put someone in place who is there just to have your best interest in mind. And secondly, the keen eye. Like me, I read contracts over and over and over and over again. Not only do I read contracts over and over again, I stay abreast on the law, on how things are either changing or how situations have arise in contractual transactions and how they kind of panned out in the court. And because I know how that is, then I take that knowledge with me when I'm looking at contracts, looking at what are some, current real life issues that are going on. What were some issues that was raised with, either non-compete or non-disclosure, and it got shut down or it got protected, it got enforced. I look at those things. As a general layman person, you're not going to stay abreast on that. And the words you're reading may seem absolutely fine, but they may not be enforceable or be in your favor. And like I just said again, because money is the distractor. If you see the money that you want, that you aspire for, then it's already skewing how you're reading the remaining 1-page or 2-page. But if you hire someone that is to do it, the money part is not going to be the distractor. Honestly, like for someone like me, at least, I know that is something to absolutely put aside. Yes, I would check the compensation provision to make sure it's something that you expect. Yes, I would check the compensation provision to see if it's something that needs to be negotiated, but it's usually the last thing to put aside to see how everything else is working. Because all of the other provisions that come after the compensation provision can actually affect compensation. I know there's, some athletes who will sign multi-year deals. I know a few in particular. I'm a former track athlete, professional, ran on a professional level, ran collegiately, all the things. And I know there's some deals out there and more so being put in front of, especially those coming out of high school, signing these multi-year deals, and it'd be a multi-year deal, $10 million deal, right? $15 million deal, 8, 6, whatever it is. It sounds great. Multi-year deal and you put million behind it. What the money's a distractor. What do you think that athlete and their family hears? Millions, multi-years. But you have to look at all the other provisions that may affect that multi-year deal. Secondly, money depreciates. If you lock me in without speaking to inflation and everything else, I'm actually getting paid less on the 5th year than I got paid on the 1st year. And I have put in more work. More than likely, if all things given are great, I have improved. I'm not the person in the 5th year or the athlete in the 5th year that I was in the 1st year. but I'm getting paid less. So it's things like that to think about. And this is not just, we're talking about provisions and things that we need to think about, whether it's a deal with a label company, whether we're talking about leagues, whether we're talking about business to business, whether we're talking about employment. We need to understand what that transaction is and what are the things that we should be thinking about. And in some of the provisions, I'll point some out now. Intellectual property, that's huge, right? You need to go put the compensation provision down. We need to look at intellectual property. You knowing why you entered into this deal is intellectual property an important component of it. What are the expectations of intellectual property ownership for one side of the contract and you as on the other side? And your intellectual property, for those who may be listening that do not know, I'm talking about trademarks, copyright. And if there's got something to do with invention with a business, then patent, right? So when you're creating some type of content, when you're providing some type of good or service, there is intellectual property involved, either as a copyright or as a trademark. And if you're someone who's contributing to producing content or providing products or services, then you're someone that's involved in curating intellectual property. So what does that look like? Is it just compensation for you and complete ownership to somebody else? Is it split ownership? Is it you retain rights? What is that? But you need to go to the intellectual property provision and read that to understand that. If you're being employed by somebody, by default, if you're employed for someone and you're creating something as an employee, that work belongs to the employer, not you, unless there's other conversations that are had. And you have to understand that depending on what you're being employed for, you have to understand what the default is. If you're not employed by someone, then it's possible that it can be work for hire for other reasons under the Copyright Act. What you providing a product or service may not still be yours, even if you're not employed by them. So go to the intellectual property provision and really understand that. Another provision that is highly overlooked is the jurisdiction provision. What state, what courts govern this agreement between us? If an issue arises, something happens, who actually governs how to deal with that issue? Is it even a court? Is it arbitration? Is it mediation? That means you're dealing with outside of the court. You're dealing with someone that's an arbitrator who will hear everything just like a court, hear everything, make a decision, and then you bind yourself to that decision, meaning you stick yourself to that decision. Or it could be a mediator who mediates, you all figuring it out, and they're there to mediate the situation. But where is it happening? If it's an arbitrator, a mediator, a court, is it happening in the state in which you're in, the state which the other party's in? You may both be in the same state or different states. That makes a huge difference because different states may have different laws or may be favorable or less favorable to your issue, depending on where you're at. Some states may be more favorable to businesses, to employers, to labels, and less favorable to employees and someone who is providing something for a business or athletes. You have to see where and who governs enforcing this contract, and that is overlooked. And that can cause a nightmare. All that compensation you may have received may go towards actually fighting in a court for an issue that needs to be resolved. Another provision that needs to really be paid attention to that's overlooked is duration. How long is the contract for? You may have a term, right? A provision that says the term of this contract is this time to this time. Like, for instance, you may agree, I'm going to enter into a 5-year term deal. I'm going to enter into that. And that's my understanding. So when I sign this contract, I know it's a 5-year term deal. But as you go through the provisions, you may see different things in the provision that, or the provisions where certain things have to be delivered or done that may push back time. There may be a force majeure clause, means by the act of God, where something can be delayed and put on hold, or contract can be canceled. But it can stretch out the duration based on what other things are in the contract that has to be done. A 5-year, anticipated 5-year deal can turn into a 15-year relationship, especially when it comes to entertainment deals, depending on what is in the contract. So looking at duration, and duration is not, again, looking at just the term, look at other clauses that speak to the duration of what needs to be done, when it needs to be done. Another one is deliverables. It goes right to duration. What are the expected deliverables of this contract? What are either party is supposed to be bringing to the table? What service or product one party is supposed to bring? What is the other party supposed to bring? See what the deliverables are. But more importantly, in the provision that speaks to deliverables, you have to look at the standard of satisfaction of those deliverables. Especially a lot of times I get this in production deals, film deals. You have to understand, I have deliverables that I have to deliver, but am I delivering these deliverables at the satisfactory level contractually agreed upon? Otherwise, that can extend duration, or it can affect my compensation. Another thing overlooked is the transfers. The transfer clause and assignments clause. Can this contract be transferred? Which means, if I'm doing XYZ for ABC, can it be transferred over here? And now I'm doing it for whoever instead of who I thought I was doing it for. I'm going to give you a little nugget here. Again, it's not legal advice, and you need to get you want something, you come for a consultation, but because you are a seeker and you are here and you're listening and you're investing with your time, I'm going to give you this nugget. Like, if you're in a contract, if you're entering into a contract, that's very important on who you're actually dealing with, then you have to look at making sure things are non-transferable, because there may be licensing that you want to give to someone as well. You want it to be non-transferable, but just giving your time in service, you want it non-transferable. It goes to the same as the assignment clause. If they can assign rights to someone other than who you expected for those rights to benefit, it can be assigned, while at the same time, those two clauses can speak to you not being able to transfer nor assign. You can't transfer the ability for your contract or you to provide a particular service, and you can't assign the rights and benefits you get to someone else. Which brings me to another clause. It's the last one I would talk about now, because these ones are very important. The parties. This is overlooked because, again, there's a conversation that obviously had to have been had, right? I get it. There's a conversation. So you think, okay, I know who this contract is between. I know the parties. But it has happened. I'm here to tell you, it has happened plenty of times. And it continues. It will happen. When you read that contract and you realize, but who's actual parties that's signing this contract and mentioned in this contract? You may be binding yourself to parties that you don't know that you're binding yourself to. And I know I said this would be a last one, but this is kind of connected to parties. So I'm gonna throw this one out here too. The signatures. That is completely overlooked. Look at the signatures, because who you think you may be entering into, are they even signing? Are they a signing party to this contract? And in what capacity are they signing? And what capacity are you signing in? Are they signing in the capacity of their representative capacity within that business, within that label, whatever it is, within that league? Are they signing within their representative capacity and you're signing within your individual capacity? Or are you signing within the capacity as a representative of some entity that you formed? So now it's entity to entity and not entity to individual. Signatures is very important. That is really, really important. Putting your name on the dotted lines. And by default, naturally, individuals sign contracts in their individual capacity. Even when you are a business owner and you're doing this deal as a business owner, plenty of times, individuals are signing the contract in their individual capacity, not in their representative capacity as a business owner. So when something happens, and it goes back to jurisdiction, you don't know where or how you're going to resolve this something that happened. You're resolving it as an individual who may be affected, not as a business, as an individual who's protected by their business, if you do not sign the correct way. I see this a lot with the commercial leases that I review, especially with transfer assignments, right? That is one of the standard, industry standard thing that a landlord is going to say. They're going to transfer. They have the right to transfer and assign all the rights of this contract, all of the obligations that you owe to them, to someone else that you do not know who that may be. You don't know who that may be, and you locked yourself into it. So it's important to really understand those particular provisions and what to do about them. So if you don't know your contract, I mean, you're already losing. If you don't know your contract, you are already losing. And again, this is everyone. Film, deal with clients that deals with film. You know, what are some things, delivery elements that you have to look at that speaks to, does my delivery elements or my production elements, does this affect duration? Does it affect my intellectual property? Who's responsible for insurance, errors of omission? What does that look like? What about licensing? Not only licensing, thinking about it from the perspective of you owning intellectual property, but who's responsible for getting licensing clearance for this production? Will you have to indemnify, which means get someone else off the hook if there's some type of copyright infringement, trademark infringement brought against this production because you were responsible for the licensing clearance? Something I want to bring up about employees, and this is why I said this contract touch everyone. I'm gonna bring up about employees, particularly I'm here in Georgia, right? And it's an at-will state, and this applies to any states that's at will. Your at-will state, meaning if I'm hired by an employer in an at-will state and I don't enter into a physical contract that speaks to, you know, how long, my duration and all that, I get an offer, I accept that offer, and it's pretty much basic under at will. That means that the employer can fire me at any time for any reason without motivation, with exception. And this is understanding contract, right? So I may have an offer, accepted the offer, I work, I'm at will, but there is a contract between those who are employers with the law. There are statutory, very specific statutory exceptions that will be deemed wrongful termination if someone is terminated, even in an at-will state. So that is a contract within itself too, between the employer, those who are hiring individuals, and the law. So when you enter into a full-on contract, then there has to be cause for termination. And usually those causes may be listed within the contract, or in that contract, it's laying out the expectations and the obligations. And of course, if you breach those or run afoul to those, then that can be cause for termination. But in at will, it can be things that, like fair employment practices, right? If in an at will state, someone is terminated for opposing unfair employment practices. I'm imposing things that are unfair employment practices that run afoul to rules or laws or policies, then that is a statutory exception. So that is a contract, right? You breached this contract. And I put that in air quotes, but that's what that is. You in an at will, where you don't enter into a full-on contract for employment, if you will, that incites a cause for termination, you still have these statutory exceptions, and one is fair employment practices. So if an employer is doing something that runs afoul to the employment laws that is deemed, unfair in those laws or those rules or policies, and you oppose them and they terminate you, they can't do that. Or if you work for an entity that's a governmental entity, then if you speak up about something or against something that violates the laws, rules, or regulations, period, right, then it's wrongful termination. That's what they call the Georgia Whistleblower Act. So even as an employee, there are contractual terms, even as an at-will employee, I should say, even where you are hired and can be fired for any reason, no reason, without motivation, there is an exception. Entrepreneurs, this is huge. This is huge. Let me make sure you're woke. Got it? You up? Ready? All right, entrepreneurs. This is completely overlooked majority of the time. We all understand the basics of being an entrepreneur. We strive for our freedom. We strive to own our own thing. All the things. But we don't think about the details, the intricacies of being an entrepreneur, especially when it comes to contracts. Especially. We stay on the basic, right? We stay on the basic that, okay, I enter a contract or I didn't enter a contract. Basic level. But when you are an entrepreneur, there are two different contract laws that may apply to you. It may be what is called the Uniform Commercial Code that may apply to you, or common law contracts. Common law contracts is what everyone is predominantly used to. Most people are used to talking about and understanding contracts from a common law perspective. But when you are providing a product, when you are an entrepreneur, when you're a business owner, and you are providing a product, the Uniform Commercial Code is what applies to you when we're talking about contracts. What are the differences between the Uniform Commercial Code? I'm just going to say UCC. That's what we say in the legal world, right? The UCC. So when you hear me say the UCC, I'm talking about the Uniform Commercial Code. So what is the difference between the UCC and common law contracts? The difference is the scope and application of how it's applied to your transactions. Because the UCC governs, like I said just a second ago, primarily transactions that primarily involve sales of goods, the common law is going to provide protections, rules, laws, whatever, that governs contracts related to non-good transactions. So services, real property. You can, I want to say this before I talk a little bit more about UCC in general. You can sell goods and services in the same transactions. Because some people may be listening, okay, but where do I fall? You just said UCC applies to those who are selling goods. Common law applies to those who are selling services. I sell goods and services sometime kind of simultaneously. What happens? How it's going to be looked at legally, right? The law is laid out to determine whether the UCC will apply to your situation or common law will apply to your situation. And how they look at it legally is they look at the predominant purpose. What is the predominant purpose of this transaction, of this contract, of this intended contract? What's the predominant purpose? Is it providing a good or is it providing a service? So if you provide a good and service simultaneously and the predominant purpose of this transaction is providing the goods, then the UCC will apply and not common law. If the predominant purpose is I provide the whole service to you and gave you goods, then common law. So if I am a massage therapist and I'm giving you a massage and then later I gave you some candles, the meditation CD or whatever came with it, my predominant purpose was the service, the massage. If I was a company that provided, I don't know, just flowers or construction material, that's what I did. And you ordered that from me and I delivered that to you. My service is delivering this product you ordered, that in which my business exists for. I delivered these products to you that you ordered from me. My predominant purpose are the products. I may have it set up where I actually deliver as a service these products to you, but the predominant purpose was for me to deliver these products that you ordered. So the UCC will apply to me. So Alakisha, why is that different for me to understand the difference between the two, and how does that do with contracts? Because when we look at the UCC and we talk about contracts, there are certain provisions that contracts are subjected to within the UCC law. There's different things that if we did actually sign a contract, but certain things were not mentioned in that contract, the UCC provides for what's called gap fillers. We'll fill the gap for stuff that's not in this contract. So where the UCC provides default rules and gap fillers for issues that's not explicitly addressed in contracts, the common law is different. there's certain elements that needs to be present in a contract in order for it to be enforceable. So if I'm operating under the common law, providing a service, real property, whatever falls under common law, then this contract that's drafted has to have certain elements that must be present to create an enforceable contract. Of course, there are some exceptions that can be raised in court, but again, you have to get to court to see if those exceptions can be raised. But the default rule, the general rule, the starting point rule is that there's certain elements that needs to be present in a contract to create an enforceable one if we're governed by common law. If I'm governed by UCC and I decide to enter into a written contract and certain things are not present, there's gap fillers that will be put in there to determine how this contract needs to be enforced. And there's default rules. Even if that's why some, companies who offer products may have templated contracts, because it applies that way all the way around or whatever, or, common behaviors established. This is the expectation, because that's UCC. But when we're talking about common law, we need to have that contract. And it's really important not to just be given a template without adjusting certain provisions that applies to your situation. So how do you protect yourself with all of this that I'm talking about? How do you protect yourself with contracts? First of all, the first thing I would say to protect yourself is to shift your mindset. If it's not already shifted, to shift your mindset. Okay, making sure you're woke here. To understanding and knowing that contracts are essential to everything that you do business-wise. In some shape, form, or fashion, you are agreeing to or not agreeing to something, and you're going to start taking it seriously. And you're not going to be excited by distractors. You can get excited about that and celebrate after you sign something that you can be happy with. Then at that time, get excited, do all the things, but you're going to shift your mind and say, this is serious business. This is not a game. And it's something that I want to know the rules to. And even if I spoke with someone about this, or someone's, I'm going to make sure I read this to see if what our verbal understanding is reflected in this written document. So that's the first thing we're going to do to protect ourselves. We're going to make sure we shift our mindset and start taking this stuff seriously. Stop pushing out products and just pushing out service, receiving products, receiving service, but do the foundation, lay the foundation, solid foundation. Then you're going to get a lawyer, right, who works for you. Get a lawyer. And I know some people might say, I don't know if I can afford one or that. I know one thing for sure. Two things for certain. You can't afford to lose everything, and you can't afford to be in anyone's court spending that money in anyone's arbitration or mediation. So whatever way you need to figure it out, it's always about asking the right questions. Don't ask yourself, can I or can I not do this? Ask yourself, how can I make this happen? Especially if it's important. How can I make this happen? And especially if you're dealing with, go back to labels. This happens a lot with labels. This happens a lot with companies who are endorsers, or when I speak of getting a lawyer, I'm speaking about you get a lawyer, one that works for you, not the company. Way too many times individuals says, yes, I had a lawyer look over this, a lawyer talked me through this. A lawyer was present. Yes, a lawyer was involved, but it wasn't your lawyer. It was the company's lawyer. And if our job, our ethical duty is to represent the best interest of our client, and the lawyer that was present or the lawyer you said you had works for the company, who interests do you think they're representing? I'll give you a second. Not yours. So get you a lawyer that works for you. Negotiate, understand, negotiate. And this is why you have to get someone that works for you, especially a lawyer. If it's one of those opportunities where you have to negotiate, whether it's a job that you're getting, even if you're working for an employer and and it's one of those situations where the lawyer is not actually going to talk to the employer, you need to talk to a lawyer to understand, what you're getting into, depending on the level of job and all that stuff, right? If it's something where it's really non-negotiable and, you can elevate up, just know the basics that you need to understand about the position and what you have, because there is contracts by actions established. If I do this, then there should be an opportunity here. Ask those things. What are my opportunities if I accomplish this? What are my opportunities of moving up? What are my opportunities of a higher pay? There's things that are around you that should inform those things, or you can do research depending on your position role. But you also ask questions. Okay, I accept this, but, is there a possibility to be on the track to do this? That's negotiating. Like I just mentioned earlier, when we're talking about intellectual property, those particular things, they're strategies. I'm going to give you another gem. You get another gem. All right. Are you ready for this gem? Because you have invested your time in getting this information, I'm giving you this gem. See, I told you to share this. Share. When it comes to intellectual property, and I do this, with my clients as well. Now, there's times that there could be individuals who will say, this is what I want, and that's it, period. Then, of course, I will have a conversation based on that instruction. But when it's not that type of conversation, this is what I do, especially when it comes to intellectual property, especially when it comes to growing your leverage to move you towards complete ownership. I have a conversation with my clients and say, listen, we have 3 categories when we're thinking about our intellectual property, whether it's a catalog or whatever it is. There's 3 categories that we're thinking about with our, scripts, whatever it may be. We have a category where this is all me, period. It's all me. We have a category where it's us. I am absolutely fine with it being us. And then we have a category where I am absolutely fine with letting go. I am the creative genius. I can reproduce. I actually created this to open doors for me. This is we have 3 sections, 3-section strategy for catalogs, scripts, whatever it may be. I'm putting it in this box where it's non-negotiable. Don't touch it. It's mine. It's mine. It's mine. Later, it's whoever else I assign it to be. This right here, it's us. We're going to both keep our hands in the pot together. And then this is, I created this to knock down doors for me. So when you're looking at intellectual property and leverage and building towards that ownership and negotiating, have the 3 prongs set so it gives you room to get to where you need to get to in negotiating. Put those things that you know that's us or that you created to open doors, put those things out. And that's what you're negotiating. And you don't just go into a situation and say, hey, you could just have this. You start with the best case scenario, but you know you're willing to come all the way down to where you're winning anyway because you were willing to give this up. And as you open doors and as you get in, then later you can start moving towards that category where you knew it was just you. You get to debate, negotiate, whatever, with it just being you, and you're able to even walk away with a no and feel fine if it's the case that you get a no, but you probably get a lot more yes because you already built leverage by putting yourself in. So negotiating, I gave you one of my negotiation strategies and mindsets. Just as you are thinking about contracts and entering contracts, you are the creative genius. Create your 3 prongs and then figure it out from there. But hiring someone who has a specialty in it will help you to think outside of how you are thinking. Also, especially this is when it comes to film or music clients, but business clients too. It could be anywhere that you have a product or service, anything that's selling. Think about back-end deals, right? So that's another way to elevate yourself and protect yourself. You say, okay, I may be accepting this up front, whatever this is, but I want to do a back-end deal. There is a risk assessment there, but a lot of times, as they say, the higher the risk, higher the reward. But also the higher the risk, the more leverage you have in that conversation. Accepting back-end deals have changed many people's careers. Accepting and being willing to accept back-end deals have helped me so much to get into deals for clients. And sometime initiating that, because if you know there's something absolutely amazing that can come out on this other end, sometimes don't sell that. Sometimes you don't have to sit in your conversation to talk about how amazing this thing is, how amazing it will be. And these are the reasons why. This is my proof to show you. Sometimes don't do that. Stop putting those cards on the table. Accept something different up front, knowing that it's going to be amazing in the back. And on that back end, you can get paid more. I don't know if you know about the story with Robert Downey Jr. and Iron Man. The situation with that, I remember, what's his name, Terrence Howard. He did an interview one time. He wasn't happy about the situation, especially after Iron Man won and he got replaced. He felt Robert didn't have his back. But the point I bring that up is him hiring and having strategic people around him, I'm very sure, like myself. It was a risk having Robert play Iron Man. They really didn't know if he did that, action figure type thing. They didn't know how it was going to go. So he accepted lower pay for Iron Man 1 up front, but did a back-end deal with, it was reported different points or percentages that he negotiated, but it was somewhere between 5 to 8%, and more reports show 8%. But negotiated points on the back end, and when he did that, he ended up making millions. And he did it again on Iron Man 2. More on the front end this time. Way more. Talk about his millions now. I believe it was like maybe 500,000 for the first one. But he went to the millions, multi-millions, high millions on the second and continued the back end. Even when it, didn't prove as successful or whatever, arguably, still made millions. And then when they brought it to, their Avengers or whatever, this is what happened. Continue to build leverage, continue to build a strategy. 10 million became his base salary. 10 million became his base salary with back end. And that's how he was able to make millions and millions and millions of dollars, because he had the foresight on Iron Man 1 to take a lower pay up front and negotiate back in. Good job. But when we're talking about film, and I'm going to give you this because you're here. I'm going to read you an example provision from a film contract. And I want you to have ownership in mind. Okay? So I can't read you anything verbatim off any, client's thing, but I will say true story. True story. All right. Company shall be considered. So this is the provision I'm reading for you. This is a company entering into an agreement with someone who's going to provide a service for this company on the film project. Company should be considered the copyright owner of the picture and the underlying raw materials with exclusive rights to perform, display, distribute, and reproduce the picture. So I want to stop there. One, the company's already saying the producer that's going to provide the service is doing so with the understanding that whatever is produced from finished product or even all of the underlying raw material, so anything to put it together, anything to make it happen, the raw materials to finished product belongs to the company. And then it goes on to name the protected rights that are afforded by copyright law. You are afforded particular rights to perform, rights to display, rights to distribute, rights to reproduce. You have these rights. And so they mention the rights that's being transferred to them. So exclusive rights, not non-exclusive, exclusive rights to perform, display, distribute, and reproduce the picture, as well as authorize others to do the same. So not only do they have the right, they maintain solely, exclusively, the right to allow others to do the same, which means that's money, right? So they allow others, they get to license it, they get to do whatever they want with the finished product. If under any applicable law, the fact that the picture, raw materials, and or any other delivery elements created by or on behalf of the producer for the picture are a work made for hire, is not effective to place authorship and ownership of such materials and all rights therein to company, or in the event that it is determined that all or any part of the picture, the raw materials, and or other delivery elements do not constitute a work made for hire for company within the meaning of the copyright law of the United States, then to the fullest extent allowable and for the full terms of protection otherwise accorded to producer under such applicable law, Producer hereby assigns to company irrevocably, exclusively, and perpetually all rights of every kind into the picture, the raw materials, and delivery elements created by or on behalf of the producer for the picture, and in any and all of its rights, title, and interest therein, in any other works now or hereafter created containing the picture, raw materials, and any other delivery elements. What does that mean in layman terms? If for some reason this provision is stating from raw materials to finished product, the company owns it all. What is produced, we own it all from conception to delivery. If for some reason by law it is determined that this cannot be deemed a work for hire for some reason, then what you're also doing in this same provision is assigning all rights, titles, and interests that you may have, that you may be able to keep. You are assigning this to the company irrevocably. So there's different ways to pass on ownership of copyright, right? It can be by a work made for hire or operation of law or by death, bequeath of heirs. They're saying if it's not work made for hire, because in copyright law, you have to meet one of the elements in order for it to qualify as a work made for hire. We throw that out a lot, work made for hire. But if you do not curate the language, or if the transaction doesn't fit to match one of those elements to be deemed as a work made for hire, the copyright law says it's not a work made for hire. So what they're saying here is if it can't be deemed a work made for hire for some reason by law, then you are already agreeing to assign any right, interest, or title that you are able to keep to give to us irrevocably. Because, and the reason why you have to put that language is put in there is because when you assign rights of your copyright, and music in particular, after a certain amount of time, those rights revert back to you. So there's certain ways that language have to be, drafted. And this is what you're not going to get. I was looking on my Instagram, and I seen someone post, and I should have saved it. I should have commented on it or something so I can go back to it so I can share it. But I didn't, so I can't. And I'm sure you've probably seen it. If not, you can look it up and you'll probably see a lot of posts people said about it. But ChatGPT, listen, I am all for AI. It's not just artificial intelligence. It is artificial assistance. It's not here to replace anything. It can help assist you. And trust me, I use it to help assist in my business, my day-to-day business things. I use that to assist, but not to do. And the post was stating, hey, if you cannot afford an attorney or someone to review your contracts, ChatGPT, look what I put. I put my contract in ChatGPT and look what it summarized, analyzed, and, gave me back. And to this person's credit, to his credit, he did say, listen, if you can afford one, you need to go do it this way. Do it the right way. But if you can't, just do this. Look what I did. And it showed how ChatGPT kind of went through provisions and broke down and explained it a little more simpler than what the contract had, like kind of just highlighted, like parse things out to make it be like, oh, I see this now in this provision that I didn't see it just reading it. Oh, I just realized this in perpetuity thing means forever. Okay, now it makes sense that I know in perpetuity means forever. And I agree, let it assist you. ChatGPT can at least be a starting point. It absolutely can. I'm happy we have that being used more than having nothing. It's a starting point. But I highly disagree with if you can't afford, then just do this. Because the one thing ChatGPT cannot do, it can tell you what's in there and probably make it more simple. But what it can't do is it's not telling you what's not in there. And I always tell individuals this about contracts. It's not always what's in the contract, it's what's not in the contract. And not only is it not just about what's in the contract or not in the contract, it is what's in the contract, not in the contract, that pertains specifically to you. Remember, I just talked about earlier one of my negotiation tactics with the 3 prongs. ChatGPT is not going to know that. ChatGPT is trying to learn, the more someone uses it, it tries to learn a rhythm, a system, a language, which you're looking at, and it will start producing based on that thing. These contract deals are as diverse as the individuals that enter into them. What we may have a conversation about one contract may be totally different than the next contract. And also, ethically, I'm not allowed to use, one of my previous clients' contracts, use that to, negotiate another contract. I'm not allowed to do that. But as a human, from having experience of dealing with so many contracts, having so many conversations, all the things, right? I am informed as a human, on a human level, with the human element. I am informed on how to use experiential knowledge with book knowledge, with empathy and sympathy. And it is literally transaction by transaction. ChatGPT can't tell you that. And even when ChatGPT parses things out, how do you now respond back to that? Do you just say no because you learned in perpetuity means this? Do you just say no, or do you go back to your catalog mindset? Do you go to other different, I have a plethora of different tactics. Do you go back to that? So for the ChatGPTers, for the strictly just template without someone checking out, and I'm fine with templates, right? For my firm, everyone, I get that everyone possibly is not in a position to retain me, right? But I have a situation where there is a subscription. In that subscription, individuals have access to contracts that they can actually customize. But more importantly, they can get feedback and guidance from me. So just getting templates and walking away with that template without at least having someone look at it, you can actually be in a worse position than not having a written contract, because you can bind yourself to a situation that you otherwise wouldn't have been. You can put yourself in a jurisdiction that you otherwise wouldn't have put yourself in, because that's what the template is for. Without having those conversations, you're just cookie cutting. You're cookie cutting your life. You're cookie cutting your ability to break strongholds. And that's what we're here on Seek Elevation. We're here to be a part of environment of growth, to break strongholds. So I'm going to tell you that. I'm going to put that in front of you. Be mindful when you're using ChatGPT and those individuals who are just pushing just AI everything, just ChatGPT everything. Be mindful that this is a serious matter. This is not a game that I'm trying to play without knowing the rules. I may start one way, but before I do anything, I'm going to make sure that I understand what I need to understand. And artificial intelligence is not going to give you that human element or quality. So that's where it's important with contracts. It just knows what to do. And to be honest with you, it's the same thing with us attorneys. Like, this is something, I'm speaking in Georgia. I attended something not too long ago where I believe it's the general counsel of the state bar was just talking about how There's a committee put together in our bar that is actually discussing and looking at this AI situation, because there are even, I get attorneys, different people, professionals are using it. And again, it's fine. I have nothing against it. Like I said, I even use AI to assist me. But that is the point that General Counsel brought up and talked about with the committee is, when do you cross the line between assistance and doing? Because that can become an issue if artificial intelligence is actually doing the work. Now there's different rules that can be violated. So just like that applies to us in the legal profession, other professionals, it's going to apply to you as a lay person. You have someone actually doing it. What argument would you make? What argument would you make if you either enter into a contract, present a contract? What you're going to say? ChatGPT did it for me? But also, more importantly, when I'm having conversations in these rooms about individuals in different capacities, and you want to be taken, seriously, you want leverage, you want to wear the ownership badge, there's different things being looked at to perceive if you are all the things you say that you are. Last Tuesday, I had Carlos Scott on, and one of the things he brought up, and I have said plenty of times, and I'm happy he brought it up, is, because he's one of the ones that's in these different rooms and having conversations, talked about the email, having Gmail, and you're saying you're high level in whatever you're doing, and still having a Gmail. They're saying certain things in the room about that. So imagine what they're saying with these contracts. And that's why certain contracts are put in front of individuals, because of already knowing the seriousness or lack of seriousness that's going to be taken from that. So that's really important. I just want to touch on one more clause. Let's see, just a little bit. This is from, I also represent, brand ambassadors and of such. And, there's different influencers and people jump on things and they just happy again being distracted by just an opportunity. But you have to think about being a brand ambassador, or now as an athlete, using your name, image, and likeness, as a business that's entering into deals, NIL deals. Some of the things you have to think about, like assignment, produce content and materials. The content that's produced, what does that look like? Is it exclusively owned by the company? Is it shared between the company and influencer, or an influencer keeps something? Those are conversations you have to have. One provision, speaking about produced content and materials, true story. As a brand ambassador, the parties mutually agree that the brand ambassador shall retain the exclusive rights of ownership of any and all content created by the brand ambassador and submitted to the company pursuant to the agreement. Nothing in the agreement shall be considered as transferring or assigning any rights belonging to the brand ambassador to the company, except to grant the company non-exclusive permission to display the content created by the brand ambassador on and for the purpose related to the company's platform application. So this is the brand ambassador keeping ownership rights for the produced content. And to go even further, you can talk about, even when you give those rights, how long are those rights to be exercised? Is it for a certain time? Once the contract ends, what does that look like? So these are things to think about. These, contract terms. I gave you some huge gems just within this time. And, I'm going to wrap it up soon, because I know how our attention span is as adults, even though this is important. I would prefer you to pause, come back, you listen. This is given to, you're not going to get, where you're going to get this at. You're investing with your time to get this information. Kudos to you. Kudos to you. So we've heard just many unfortunate stories of entertainers, athletes, creatives that, are now trapped in these contracts that they deemed unfair. But now that we know, they were unfair before they signed. Like I said earlier, they were unfair. But who did they have look at them at the contracts? Was it the company's attorney? Was it their attorney, or was it no one? Was it them? And so despite working so hard, they have no rights to their work or their brand. Oh, we can't just this future segments. We'll get into it. But just giving up the work, but also your brand. Jane Carter, that was the hair products I used. Her name. Jane Carter's used her name for her hair products, and thought she did all the things that she needed to do, from trademarking to everything else, but got an opportunity, excited about an opportunity. And you can go find this interview. It's on YouTube somewhere, where Jane Carter situation, where, she lost her own rights to her own brand, Jane Carter contracts, what was in the contract. You walk away from something you did for over 20 years. You built it for over 20 years. Someone becomes very interested in it, and you enter into a contract that can change your life. A lot of people say, I'm just going to do it because I'm already living in this situation. What can be worse? I am accepting this contract. I need a breakthrough. I'm already struggling. What can be worse? I'll tell you what can be worse. You go from already struggling to entering into a contract, building something amazing that someone's benefiting off of your back, end up snatching it all away and sending you right back to where you're struggling. But now you're struggling more, because not only are you struggling possibly financially, you're struggling mentally, you're struggling emotionally. It can be worse, much worse. So these contracts are a big deal. But just like there's stories of so many, individuals who enter these unfair contracts and don't get it, there's also stories of creatives who not only worked hard, but they worked smart. By fighting for their rights, their ownership, and handling business. Even if it took them time, you're right, some people had to learn. Some, it may have taken time to learn. But they're open and they learn. But some already knew walking into it. I got this. I'm going to do this. I mean, Dame Dash, like him, love him, hate him. That's his whole story. That was his thing. Like, I see all these people around me. I know just as much as them. These corny, as he says, cornballs, rolling on these titles as if they're bigger and better than me. They don't know. I know more, and I know the culture, and I know this. Why am I even? I'm going to say no. So they made it and like the way he went about things, but he knew in his mind, I'm going about it this way. And if I get no's here, I'm going to create a yes. And speaking of Dame Dash, you have Jay-Z, right? Sean Carter, like him, love him, whatever. And arguably is the greatest rapper. I said arguably because some people say, are you kidding me? I don't say it is. I just say arguably because some people say he is, at least according to Billboard. And with over a dozen Billboard #1 albums, over 240 million records sold as of 2025, and more than 20 Grammys, I can see why some people, it's easy for some people to say that he is. But then I can also see why some people say no. Those are commercial accolades. It doesn't make up for, the talent we're talking about. Those commercial accolades are not validations, are not measurements. Yeah, he may have gotten those things. So Even though he got those things, he's not the greatest rapper of all time, such and such is. That's not what we're talking about. We're talking about his music career isn't just fame. He's got the fortune to match. And as of 2025, Jay-Z, it is reported that he's worth $2.5 billion. I believe he was hip hop's first billionaire. Something was between Diddy and him. I can't remember. I know 50 was in that conversation, but it was something between Diddy and him. But I believe he was the first hip hop's first billionaire. If not, put it in the comments later. If not, but he is the sustainable one. And while much of his wealth, did come from multiple, lucrative liquor businesses, and he have done some angel investments. Listen to his raps, listen to some of his lyrics, things that he's saying. He's done some investments, but he used his extensive music catalog, right, to position him as well. How can he use that extensive music catalog? Because he made sure to own it. How could Jay-Z make sure to own his extensive catalog? Contracts. What we're talking about now, contracts. So we know he co-founded. Dame Dash said, forget all these no's. He got a lot of no's. Forget this. Let us do what we need to do. And they founded Rockefeller Records. He co-founded Rockefeller Records with Dame Dash and Kareem Burke. They founded it. Let's create our own yes. We don't want the no's, and we also don't like a lot of these contracts. So they created the Rockefeller, dropped his debut album, Reasonable Doubt. And that's a whole other conversation for another segment. The photographer, the photographer, that Reasonable Doubt, that was the issue. Talk about ownership. So although he may have gotten ownership with this, he didn't think about that ownership when it came to getting that picture done, getting the photography done. Didn't understand at that level. But anyways, they did this. And he wanted to own his music, and he wanted to own his brand. And he knew that he was going to expand into other areas of the entertainment industry, of business. And things didn't work out, obviously. Things didn't work out with those three. But he went on and he decided to start his own solo company, Roc Nation. And because he owned his catalog, understood contractually what needed to be in those contracts, he later released his music on Roc Nation. And they went on from, him already having music that can come there to release, to bringing other artists on, expanding into sports with Roc Nation Sports, which is worth, I believe, $203 million. He even, have education with the Roc Nation School for music, sports, entertainment. So he knew, entering into this contract, with this, what I need to understand in this contract that's going to help me in the future, not just to continue to perform, be paid for continue to perform, but how can I use with this performance, this talent, this genius I have to create leverage and make sure I protect it and speak to that in contracts, and became a full-fledged multi-million-dollar music brand. If we juxtapose that, if we compare that to, Taylor Swift, when we talk about contracts, we all heard about, or if we didn't, look it up. For most of us, heard about the situation between, her and Scooter with her masters, right? She, a talent, obviously, those contracts, every provision wasn't looked at. And we know the music industry is notorious for being brutal, especially for young and up and coming artists who don't know any better. She was still a teenager, giving away rights. I don't know if it was one of those situations where the label or manager attorney was present and it felt like an attorney was there, or if it was a situation where her parents was looking at her contract, or I don't know. But, and I know there's conversation about some level of involvement with the dad too. I didn't really dig all into that, but I do know that the master recordings wasn't protected at the level that she wanted it to be. And we know the master recordings, that's significant. The master recording's the original. So you have a composition that someone writes as a writer, right? And the songwriter can keep rights to those, but a lot of times they pass up those rights too. But then you have the master recording, which usually the songwriter don't have rights to, unless there's a conversation about that makes it look otherwise. But didn't have the rights to it, and by her not owning the masters and the company, the label owning Swift Masters, they had exclusive control over how and where they could be used and any money generated. So what she had to do was be genius, right? This is what I was saying before about the 3 prongs. What do you give up? What do you share? And what do you keep? Because if you decide I'm going to give up something, remember, you still are the genius that can recreate. And so she fought and she fought and she fought. And I believe, if I'm not mistaken, Kelly Clarkson may have gave her this nudge. But she decided to go and re-record. When Big Machine Records was bought by Ithaca Holding for $333 million, was bought, and they brought the masters and everything. Ithaca Holding owned the masters, and so Teller stopped fighting. Scooter went here. She left Big Machine and said, you know what? I'm going to go ahead and re-record. She turned her misfortune into success. She signed a new label deal, and I'm sure this time she came in with experience on how to look at this contract. She's in the third prong that says mine. Not in us, not in yours, mine now. And she signed a new label with Universal Music Group. They allowed her to control her future work, and she went on to re-record most of her previous albums, new masters, and was telling her fan base, and we know how the Swifties are, don't go there, go here. Don't go there, come here. But she understood contracts. So that's someone that had to learn, right? Like I said, I understand some people learn. She's someone, obviously, that had to learn and do it better. Jay-Z, Dame Dash, they knew what they were actually doing. Robert Downey Jr., we talked about, okay, I'm going to accept this up front, but had people around to say, these are other ways to do it. So these contracts can change your life for the better or for the worse. Understanding contracts. And moving forward, we're going to start taking those seriously. You seekers, my seekers, we're going to start taking it seriously. We're going to stop just entering into things and saying, oh, I just know I want this opportunity. I just want this money. I just want this affiliation. So I'm not going to really read the contract. I can't afford an attorney to review this for me. So I'm just going to skim it. I can't afford an attorney, so I'm just going to enter it in ChatGPT and let it simplify it for me. But in the simplification, There may be things that are missing. Also, in a simplification, individuals that you're talking to, they know. They know. I'm telling you, they know. We're in the rooms and we know. Those who sit at the side who have to advocate for individuals, we know. And we know the things that individuals are comfortable saying. I read a quote somewhere. It was just talking about in general with people gossiping. It was something, don't quote me verbatim, but it was something like, don't tell me what the person said. Tell me why they felt comfortable enough to say these things to you. And what did you say? That's beautiful for on the basic gossip level. That's cute. That is so cute on the basic. I agree with that. But when we come to business transactions, I'm going to tell you what these people say about you, who are not taking things as serious or as professional as you should be. I'm going to tell you what they're comfortable saying to me and others who advocate for you. And I'm going to tell you why they're comfortable saying it. They're comfortable saying it because you're asking for something from them. And we're trying to advocate to get that. They're comfortable for saying it because they want something from you and they want it all. They're comfortable saying it because if you're not taking it seriously and you're building your billboard in which you want someone to look at, the way that you're building it, they're comfortable in saying it. And they're comfortable saying it to us because we're the ones there to advocate. And the one thing that we're trying to advocate is using leverage. And the one thing they're trying to do is dismantle it. So they're comfortable with dismantling any leverage that we try to bring to the table. And I'm here to say that talent is not enough leverage. Talent is amazing. It will get you into the doors and it may get you on higher floors depending on the talent you have. But once we get into the rooms, it's the same conversation. How those conversations go depends on the billboard that we build. And if it's already perceived that you're someone who don't take contracts seriously, that's the ultimate. That's easy game. You don't take contracts seriously. And people know if you don't. So I gave you the gems that you need to start with that in hopes have elevated you, have shifted your mind, especially when it comes to I can do it all on my own, or something is 1 page or 2 page, so it must be simple. Let us start handling our business. We're not going to be signed, sealed, and screwed. Not anymore. Unless that's what you intentionally are choosing to be. We don't want to do that. We don't want to do that. So I hope this has been extremely, extremely helpful. We got some people that are elevated and ready to go. That is a wrap for today, for the Seek Elevation Experience. I thank you for tuning in. I feel your presence. Even though I'm not right here, right now, I feel your presence. This is, I believe, one of the episodes that you will save. You will go back and you will listen to it again You will meditate on it. You will affirm to yourself that you have elevated and that you are taking your business deals, your business transactions more seriously, not only for your protection, but for your perception. Where there are tons of people, tons, hundreds of thousands, millions, who's possibly doing all that you're doing, it begins to narrow all the way down when we start having the conversations about who is doing it with excellence, with seriousness. So, thank you so much for tuning in. I know this have added value to you. This powerful conversation have added value to you. You listening, whether it's watching the live stream or on the podcast, adds value to this conversation. Put it in the algorithm. Let this spread to empower more people. Remember, the more you know, the more you grow. The more you learn, the more you earn. But when you share, you show care. Don't keep this knowledge to yourself. No, spread the wisdom. Tag friends. We tag about all the other entertainment and all these different things. Tag your friends to be elevated. Let's continue to grow this community of seekers who are seeking an environment for growth, to break strongholds. Let's elevate together. Until next time, keep striving, keep growing, and most importantly, keep seeking elevation, peace, and progress.